If you have an application with the Home Office and you think that the application may get refused, or if it does get refused, what can happen to you? Number one, if the application gets refused, you are likely to get a right of appeal. If you have, if your appeal, if your application falls in one of those categories, then that attracts right of appeal, you will get a right of appeal. If your application does not get a right of appeal, the Home Office may give you a decision without any option to appeal, which means certify your human rights claim more likely and say, oh, you do not have any human rights in this country at the moment, and therefore you must leave the country now, before you could be detained. If you are given a right of appeal, so today I'm going to focus on the right of appeal. Let's say if your application gets refused and you have been given right of appeal, I'll try to focus on this part only. My name is Barrister Ghulam Mustafa. I work at Lowland Solicitors. I deal with immigration, nationality, human rights, immigration appeals, and anything and everything within the immigration. What can happen if you are given right of appeal? Once you are given right of appeal, you have 14 days from the date of decision to make an application for appeal. Which means you need to fill up appeal form, and you need to submit the appeal form within 14 days before you lose the right of appeal against the decision of the Home Office. Once you have lodged the application form for appeal to the tribunal and paid the relevant fee, I believe it's £80 for the postal and £140 for the oral hearing request. Once you've made the payments and the appeal is lodged, which obviously can be done which is normally done online, then the tribunal will start processing with your appeal and will inform the Home Office that you have an appeal pending against their decision. Once the appeal is pending, then you need to wait for the tribunal to send you some further directions down the line. So it can take few weeks up to few months. So it does not happen within days or within hours of you submitting the application. So do not worry if you do not hear anything from the tribunal. Once you have submitted the successful appeal on the portal, you need to wait. Once you are in receipt of the directions, read the directions. They are very important for you to follow. Normally the direction says that you need to give a skeleton argument, you need to provide a paginated bundle for the Home Office and for the court, and you need to provide witness statements and etc. So you need to follow the directions which will be given on the direction page, which normally comes through the email. You need to keep checking your email just to make sure that the tribunal emails does not land in your junk box and you do not open or you do not have access to that email address. So try to give the email which you normally use day to day. Once you have followed up with the directions, you have provided the skeleton arguments and you have provided the paginated bundle to the tribunal and stuff, the Home Office has a right to review your appeal and all the evidence that you have produced. So there are instances where the Home Office actually review the bundle and then they come back and they say, we would like to withdraw the appeal, we would like to withdraw the decision, and if you are happy to withdraw the appeal. If that happens, most likely it is a good news, because if they have reviewed their decision and they've read your papers and the appeal bundle, and they have realized that they have made some error or mistakes or applied the wrong law, or maybe refused the application on the wrong basis, and they are now trying to rectify their mistake, it's a good news. And then they can actually, you can withdraw the appeal, and then they can grant you this stay or the application that you have made to them, for whatever visa you could be granted. If they review the appeal and they still decide that they still stand by their decision, which means that the appeal will continue to the next stage, which means the appeal will be listed for a hearing before an immigration judge. Let me make it clear, the immigration judges do not work for the Home Office. They are employed by the state, and they work independently, so they are not employed by the Home Office, and they are not their staff, or they do not follow their instructions. So they are independent judges. They just want to listen to your case. What are your reasons for you to stay in this country, or for whatever application that you have made, and do you meet the requirements? And if you do not, then they can sometimes see outside the rules, and still allow your appeal, but that depends on appeal merits and stuff. And they also see the Home Office reasons and objection for you to stay in this country, or for whatever application that you've made. When you have a hearing, you can represent yourself, or ideally you should hire a good counsel who can actually represent your case, and argue your case on your behalf to the Home Office in the tribunal before and obviously the Home Office will be represented by the Home Office team. So they will send the Home Office will sometimes also instruct counsels, which they call agent counsels, and sometimes they have their own appeal team that will the Home Office representing officer who will be there to represent the Home Office. Once you have had the hearing, the Home Office, the judge will decide about the appeal. The judge can actually give the decision on the same day, but most likely what happens, the judge send a decision after few weeks. There is no time limit on how soon the judge should send, but normally the decision should come within few weeks, let's say 3 to 4 weeks time. You will have a decision from the tribunal either allowing your appeal or dismissing your appeal. If your appeal is allowed, then the Home Office has the right to challenge. Again, 14 days they have, or sometimes they do not wish to challenge and they accept the decision and they grant you the stay. In that case, they will be in touch with you. If the Home Office has decided that the judge has dismissed your appeal, then you may have a right to appeal for the permission to appeal to the upper tribunal if you believe that there is an error of law which a judge has made when writing your decision or hearing your appeal. But in that case, ideally you should consult someone who has a specialist experience in dealing with appeals, who can actually look at the merits, look at the reasons, and then they can advise you further on the error of law. So that's how the appeal process works in the UK. I've tried to explain it in brief. If you do have a question on this, please get in touch with me and I'll try to be as helpful as I can. Thank you.